Hello, everyone. Thanks again for attending our Tuesday morning livecast. And with me today is Tyler Happe. Tyler is a founding partner of Happe Reed Law Firm here in Sacramento, California. Actually, we are in Fair Oaks, California. In addition to that, he is an owner of Main Street Capital Partners with us. He is also a note investor and has done a lot of private placement security work for raising private capital. And today we're going to talk about a very topical and timely information concerning a recent Supreme Court decision that I know a lot of note investors were very concerned about, and especially us in the second space. And we have some good news for you. Tyler's going to cover that. First, before we do get started, though, I would like to remind you of our boot camp that is going to be held in San Francisco on the July 17th, 18th, 19th at the Doubletree Hilton Hotel near the airport. Tyler will also be a participant in that seminar. He'll have a portion of it where he's going to talk about Dodd-Frank, about the Consumer Finance Protection Board, about raising private capital, about the different Regulation D opportunities, about crowdfunding, and so on, as a participant in the seminar. So if you really want to learn about the note business and get 100% education, then this is a very good seminar to attend. We're having it in San Francisco on July 17th, in Houston on August 14th, and then the first week of October in Boston. So please go to www.notemogul, notemogul.com to hear all about it. So thank you. Now let's get started. The Supreme Court week issued a ruling on stripping mortgages in a Chapter 7 bankruptcy. It was a long-awaited ruling, and I've got Tyler on today to kind of give us indication of what the ruling was all about, and to make us more knowledgeable about what is going to be happening going forward. So first of all, I'd like to ask Tyler just to explain to everybody the difference between a Chapter 7 and a Chapter 13 bankruptcy, and then we'll go into how this ruling pertains especially to second note holders. So Tyler, can you give us a brief summary of the difference between a Chapter 7 and a Chapter 13?
Absolutely. Chapter 7 is a liquidation type of bankruptcy. It's intended for small business owners typically qualify for it. Some individuals qualify for it. The idea is that the bankruptcy trustee will gather all of the debtor's assets, sell them, and pay off pro rata to the creditors in that bankruptcy. A 13, however, is called basically a repayment plan. It's a wage earner bankruptcy. So almost anybody with a job who can pass what a means test can file for a Chapter 13 bankruptcy. And the trustee, instead of gathering all the assets and liquidating them, will put together a plan that's for a period of either 3 to 5 years that the debtor then will have to pay a certain amount of their income to that trustee, who will then divvy that up pro rata and pay off the unsecured creditors.
So this ruling, I think we were getting a lot of questions from people about what's that going to do to our business. Can you give us a little information about why this Supreme Court ruling, why it even got before the Supreme Court, and what was happening that caused the the case to even get before the Supreme Court.
Yeah, absolutely. So I guess we'll go back and do a little bit of a history lesson here. With those two different types of consumer bankruptcies, the Chapter 13 and the Chapter 7, since about 1992, there have been cases dealing with second mortgages. The bankruptcy code allows for certain liens to be stripped in Chapter 13 bankruptcy. It doesn't provide for the same type of relief in Chapter 7. So for a period of time, Chapter 13, even in junior mortgages, which the code is kind of, it's interesting in and of itself, but junior lien holders could potentially lose their secured interest in a debtor's primary residence through this process that we call the lien strip. Now, this was only applicable in Chapter 13 bankruptcies. In 1992, there was a case called Dewsnip versus Tim, where the Supreme Court made a determination that in Chapter 7s, where the junior lien had even the slightest bit of equity, a debtor could not strip that lien down. So if there was $1 worth of equity, a debtor could not strip that lien down to nothing. And the court came to that conclusion based on some policy decisions and some reading of the statute, which is it's 506 506A and D of the bankruptcy code. But ultimately, from about 1992, when this lien stripping started happening up until the present time, the idea was that with junior mortgages, Chapter 13s were typically a little bit more risky, meaning a lender could lose his or her security interest in a Chapter 13, whereas in a Chapter 7, they typically wouldn't under most circumstances. With this financial crisis, however, and with kind of a revamp of the bankruptcy code that has happened since 1992, certain courts were looking at this Dewsnip decision and saying maybe this isn't exactly what the Supreme Court intended to do. So particularly in the 11th Circuit, which is Florida, Georgia, and Alabama, the circuit courts were saying, or the district bankruptcy courts were saying, we're going to allow lien strips in Chapter 7. We're going to allow lien strips in Chapter 7 when the junior lien is wholly underwater. That means the senior encumbrance exceeds the property value. So if there was absolutely zero value securing that junior lien, then the bankruptcy court was saying, we're going to allow this lien strip under 506 in Chapter 7s. And it was kind of revolutionary because every other jurisdiction in the country was saying, no, they weren't allowing lien strips. They still allow lien strips in 13, but they weren't allowing them in Chapter 7. So what happened is Bank of America had a couple cases that went through this 11th Circuit in Florida, and they ultimately were granted cert by the Supreme Court. The case is Bank of America versus Caulkett, and that's actually a combination of two cases. It's Bank of America versus Caulkett and Bank of America versus Toledo.
Put the link up.
I can't remember the other, Toledo Cordero or something. But the idea is that the courts decided this or they made this decision because there was a split of authority, meaning the 11th Circuit was saying one thing and the rest of the country was saying something else. I've put up the link right here to, if you want to view this opinion. It's actually a really short opinion, 7 pages long. It's something worth reading. Why does it matter? Well, this question here is settled today. But if you read the opinion and you kind of digest it a little bit, what it really says is that the Supreme Court might have left this decision open for some other challenge later down the road. But for the time being, the decision rests. Right now, there are no lien stripping allowed in Chapter 7 bankruptcies. This link, incidentally, I think was sent out in an email a couple weeks ago. If you got that, you can click right in there and get it. But otherwise, write this down. Otherwise, you can Google Bank of America versus Caulkett, and that's spelled Caulkett. Pretty easy to find. There's a lot of authority on it out there, a lot of news, because this was kind of a monumental decision.
Great. Okay, so now that we kind of have maybe a sigh of relief for a lot of people that were concerned about this, to be quite honest with you, we weren't that overly concerned. We've always had the scenario where a second could be stripped on a Chapter 13, and that was kind of the most important one to us. Chapter 7, if you would, Ty, there's a couple of things that I think could help people understand bankruptcy, and one is a reaffirmation, let's say, of the home. Number two is when a lien is stripped, what does that actually mean as far as the security and the debt that's related to that? So
absolutely. So I'm going to answer the first one, or the second one first. In Chapter 13, when a lien is stripped, it means that the security interest is separated from the debt. So now we have an unsecured debt. Even though it was secured when it was originated, now we have an unsecured debt. And that unsecured debt gets paid off as part of the debtor's Chapter 13 plan. Remember, that's the 3 or 5 year period of time where they're going to be making payments to the trustee, and the trustee is going to be paying out pro rata. Interestingly enough, a lot of second liens make up a substantial majority of a debtor's estate once that lien strip has occurred, or they make up a substantial majority of the unsecured portion of that debtor's estate. So if the debtor is to pay $300, $400, $500 to the bankruptcy trustee, assuming the proof of claims are all there and there haven't been any challenges to that debt is an unsecured debt, which gets its lion's share, if you will, of that $500 a month or $300 a month. Now, there are cases where a 13 nets, $100 or $200 a month, and a majority of that goes to pay the trustee in administrative costs. But it still exists, and there is a way to get paid even after the lien strip has occurred. Now, the lien is actually still part of the estate, technically, until that debtor has completed their 3 or 5 year plan. Meaning, if that debtor stops making payments to the trustee at any point, that lien strip is no longer valid, and the lien still exists. So how we see it, a significant majority of Chapter 13 bankruptcies actually don't make it through that full 5 year plan or that 3 year plan, whatever the case may be. So there might be a period of time where you can't really do a whole bunch on that file, but in a couple years, it'll come back and you have that security and you can start renegotiating that lien again. I've forgotten your first question.
A reaffirmation.
Yeah. So, a reaffirmation it's with the filing of a bankruptcy petition, which would ultimately lead to a discharge if everything went right. That discharge only applies to pre-petition debts, meaning debts that were incurred prior to the date of filing. Say I filed today on June 9th, and any debts that I owe prior to June 9th are going to be wrapped up into that bankruptcy. And that includes these junior and senior mortgages and whatever the case may be. Now, if they're going to be discharged or not, that's what the bankruptcy court's going to decide. That's what this lien strip issue is all about. However, after the filing of a petition, debtors oftentimes look and see which assets do I want to keep. And their primary residence, their homes, those types of things are typically things that they want to spend, all of their efforts and energy keeping. So they will enter into what's called a reaffirmation agreement, which is basically reaffirming that debt, getting it back on track, and excluding it, if you will, from the bankruptcy estate.
Okay, so I think one of the big issues that we deal with, and what we get a lot of questions from investors about is that when we are negotiating with a homeowner, in many, many cases, what we were willing to accept as a payment, or what investors are willing to accept as a payment, is far more than what the homeowner has to pay in bankruptcy through the trustee. Because let's say that we have a mortgage that we purchased that has a $500 a month payment on it, and the person hasn't paid for 3 years, which is they're $18,000 in arrears. The trustee often will make them pay those arrearages on a monthly pay. Is that correct?
Yeah, I mean, if there's money in that payment plan, then certainly it's all going to go towards the entire balance.
Okay, so now all of a sudden the homeowner couldn't pay $500 a month. They certainly can't pay $900 a month with a $500 mortgage payment plus a payment to clean up those arrearages. And so the likelihood of that Chapter 13 going to discharge, that's another thing that people misunderstand. There's two terms I'd like you to explain in just a minute. But in order for them to go to 3 to 5 years, they have to come up with a lot of money each month, and they just can't. They don't make it. They couldn't make 500. They certainly can't make 900, and the bankruptcy then is dismissed. So can you just give them a definition of the difference between a dismissed and a discharged bankruptcy?
Yeah, I mean, a bankruptcy ends one of two ways. It ends with a dismissal or a discharge. A discharge is what the debtor is striving for. What they want is for the debts, the pre-existing debts, to be discharged, meaning they are no longer payable obligations. A dismissal is just a dismissal. It can either be at the hands of the debtor, or it can be a forced dismissal. In Chapter 13, dismissals happen all the time. When the debtor stops paying on their plan. In Chapter 7, people dismiss for all types of reasons. Maybe they decided once they got in here, they've got all of their creditors sitting in a row, and they can talk to them and figure out that they don't need to go through this process. But a dismissal basically acts almost as if no bankruptcy had ever filed. The reality of it is that, you know, it might affect the debtor's rights in the future, but from a creditor standpoint, a dismissal is as if there was no bankruptcy at all.
Okay, so most of the Chapter 13's in a dismissal, not a discharge, and so we end up going right back in the same position that we were when we started. A lot of people really, really fear bankruptcy, and I think one of the things that you people as investors have to keep in mind is that under the best of circumstances for the debtor, if a loan is stripped and they do go all the way through bankruptcy to discharge, and that means that now that second lien does not have the security of the property, the debt still remains. It's just not a secured debt, and that debt is on the person. Now, can you explain? Has nothing to do with this ruling, but can you explain on a Chapter 7? It differs a little bit in that if there is a discharge in a Chapter 7, the debt no longer can be collected from the person, but it still is a lien on the property. So can you kind of explain that a little bit?
Yeah, let me clarify for a second. When we go through the Chapter 13 plan and reach that discharge stage, there is no debt, there is no lien. If it's been discharged through with a lien strip, there is no debt, there is no lien. Now, if you go through a Chapter 13 or a Chapter 7, a Chapter 13 that doesn't have a lien strip motion in it, because typically a borrower is going to have to make a motion to do it. So if we go through a Chapter 13 with no lien strip, or we go through a Chapter 7, and any Chapter 7 now since this Caulkett case, The discharge basically separates the security from the note. And in doing so, it eliminates the note. It eliminates the individual's obligation to repay. But what it doesn't do is eliminate the security interest in the property. So whereas a lender cannot go back and say, you owe me all of these arrears, pay me all of these arrears, those types of things, the foreclosure process is still the remedy that exists, either, depending on the state, judicial or non-judicial. So the reality of it is that if the homeowner wants to keep the house, they are going to have to participate in some type of negotiation. Now, again, it's not a debt that they owe. It's just a security interest on the property. It'd be the same as if, somebody new moved into that house without a new mortgage and without triggering that due on sale clause. That deed of trust still is enforceable against a property, but just not against the person that lives there anymore.
Okay. All right. Great. I'm not an attorney. You probably discovered that in some of my comments. That's one big advantage that we have, is having Tyler to really keep abreast of all of these decisions, to understand foreclosure, to understand bankruptcy, and just what the legalities are, to be a compliance, our compliance officer for Dodd-Frank, for Consumer Finance Protection Board, and just to make sure that we and the people that rely on us for information are not making serious mistakes that can cost you really tremendously. One of the things that I want people to kind of take away from this, though, is that bankruptcy, while it is certainly something we'd rather not see, it's not that onerous. It really is not that onerous. You can deal with it. The biggest, I think, setback for the investor, for us, is that when someone is in bankruptcy, we just cannot communicate with them anymore until something happens, that they're either dismissed and we can go back. But we can, and clarify this, Tyler, we can talk to their attorney and the trustee. And in many cases, we haven't had the ability to communicate with the homeowner. They won't talk to us, let's say, but when they go then to declare bankruptcy, we have the ability to talk to their attorney. We have the ability to talk to the trustee. And in most cases, if you're buying your notes right, what you were willing to offer, or what we were willing to offer the homeowner, is the trustee or the attorney is kind of shocked that we would be willing to work with them to that regard. So I guess the whole gist of this is, don't let bankruptcy keep you from investing in trust deeds and mortgages. They are certainly a part of life. They don't happen that often. And when they do, the ones that go to fruition are not that many. So please, if you have questions of us, or if you have questions of Tyler, please email us your questions in. We'd be more than happy to answer them. And again, I think it was a victory for us note investors. Certainly that the courts recognized, or at least temporarily recognized, that just because the house lost value doesn't mean that somebody can just easily walk away from that by declaring bankruptcy. And the second thing is that the real estate in most markets is recovering, and the equity that the notes have is coming back. So a couple of real strong points in our favor. So again, thank you for watching. And again, I'd like to remind you about our webinar, the Note Mogul webinar, or a seminar that's going to be in San Francisco on the 17th through the 19th of July. we'll be covering this. We'll be covering a lot of other topics from the legal point of view. Tyler will be there spending a lot of time teaching the seminar. And we look forward to having you there. Just go to notemogul.com and all the information will be there. Again, thank you very much, and we'll see you next week.